All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning. Our first case today is in re amendments to Florida Rules of Appellate Procedure, case number 2024-0317.
Good morning, Your Honors. Chance Lyman here on behalf of the Appellate Court Rules Committee. I just want to start by thanking Your Honors for rescheduling this argument in light of the storm. We're here today to propose 4 rule amendments to the Rules of Appellate Procedure. 2 are rather technical, and the other 2 create a procedure to provide for a non-final appeal in stand-your-ground cases, immunity cases, in both the civil and criminal contexts. That's the section 776.032. I will begin by saying that those referrals for the, and that's where I'm going to focus my time today, Your Honors. Those referrals came from DCAs that were struggling with the remedies that were already provided for those immunity determinations. Courts were using certiorari and prohibition.
Can we talk about
yes.
What the nature of those struggles really is? Because it seems to me that perhaps if we bifurcate the question between the civil context and the criminal context, it would seem that in the criminal context, prohibition, I mean, I don't have data, that's why I'm asking the question, but like logically it would seem to me to work just fine. And perhaps you have a better case in the civil context about why you need something other than a writ of prohibition. How strongly is the case sort of before you guys that, or the committee, that we should amend the rule with respect to both civil and criminal proceedings?
So the struggle, Your Honor, came primarily from the use of prohibition. It was a time limit struggle. I can tell you that's what we see when we pull the
Tell me how it bites any differently than any other time limit.
The absence of a time limit in prohibition was resulting in unreasonable delays and last-minute continuances of trials. That's what we see in the Snow decision, the discussion there, and adding a time limit to seeking a review of a stand-your-ground determination was designed to assuage that. The other issue is sort of a square peg in a round hole with the use of prohibition. It's not a review writ traditionally. It's a writ that's forward-looking. It seemed like, and this is expressed somewhat in the Nadell decision, it seemed like that judge, the DCAs are struggling with applying that review mechanism for this type of ruling, which is really, I think, uniformly used to review an order of the court. And that's not traditionally a use of prohibition, although I will certainly say there.
But once it's established that it's okay, then the struggle sort of, it's kind of it's sort of an academic struggle, right?
I would say
they're struggling with what we've said to a certain extent.
To a certain extent, Your Honor, yes.
Well, we've said what we said. And their deliverances and their struggles are, I guess, interesting, but it's more significant what we've said, unless it's unreasoned.
Well, I would say this: the Supreme Court has the ability to create the administrative convenience of a non-final rule here, and we think that mechanism is appropriate in light of the fact that these are being reviewed rather regularly. So this wouldn't be an issue of changing caseload. It's really just transforming something that courts are already doing into essentially a black and white procedure, if you will, and giving it the time limit that some of the courts are identifying as being a bit of a problem.
It does seem, though, that part of the concerns against it in the criminal context are at least that it wouldn't just put a different label on the same quantity of things, that it would actually kind of turn something that still is understood to be extraordinary and has this high bar into something that they would feel almost obligated to do in every case.
Your Honor, and on that point, the committee does not feel that we're asking this court to create a right, and I think that's what the opposition, the Public Defender Association is taking that position in terms of the criminal amendment. This is again an administrative rule within your jurisdiction under Article 5. It does not create a constitutional right. Certainly, this court is not in the business of creating constitutional rights. This is just something that, again, proceduralizes, for lack of a better word, something that is already happening.
Yeah, and we're not being critical. I mean, you guys are obviously, we're not faulting you through these questions for suggesting what you've suggested. I mean,
we're actually saying thank you in our special way.
I hope I am too.
Is there, so there's the Corbett case, I think that was out of the 5th, where because of the difference in how these cases are treated, whether they're treated, or whether it's challenging a procedural issue versus a merit issue, and if it's procedural, it goes into cert. If it's merits, it goes into prohibition. There are situations where the parties have presented a writ of prohibition. In reality, it presented a procedural issue. That would be cert. It's barred under 30-day rule for cert, but prohibition, it would be discretionary. Do you see this kind of ongoing conflict in the district courts between, our obligation to treat petitions as seeking the appropriate remedy, but then running up against an issue when you have a discretionary deadline for prohibition and a hard deadline for cert?
Absolutely, Your Honor. There is a bit of a procedural trap there in terms of, you may have picked the wrong writ. Now, certainly the rules do provide for, treating a remedy as if the correct one had been sought. But in most of the cases, there is still this struggle about, are you making a procedural challenge? Are you making a merits challenge? And frankly, that is one of the main reasons that it just makes sense to call it what it really is, which is an interlocutory appeal. I analogize it to what's just happened with the punitive damages amendments. I think we were always using certiorari and sort of, I don't want to say struggling with that, but certainly it was not an ideal solution. And this court just recently, adopted, I think, a very similar interlocutory rule procedure just to bring certainty to that area. This is our overall theme. Certainly is bringing certainty in an area that seems to be uncertain.
But some of that stuff has to do with the challenge that the certiorari standards have sort of this substantive complication to sort of the standard of review, as opposed to whether you call it prohibition or you call it an appeal. You're going to be looking. It's going to essentially be a de novo review legally of what's going on. Certiorari has that weird layer of like how off the reservation legally does it have to be, kind of thing.
Absolutely,
right?
This something more than legal error, yes, has to exist here. But part of the committee's thinking on this was sort of the writ of prohibition in this context doesn't seem to be the best fit when you could use an interlocutory appeal rule, and it's sort of to the extent you found yourself in a position where you are actually making a procedural challenge to the determination, then all of a sudden you would be subject to a different standard of review than one would be under the prohibition fit that's been made. And again, I think it's a little bit of what's going on here is just sort of I want to say, appreciation or respect for that extraordinary writ and sort of keeping it where it's supposed to be and utilizing the interlocutory appeal mechanism to sort of take care of something that walks like a duck and talks like a duck in that sense. So, I don't think there's really any question that the statute itself provides for immunity from suit. To the extent there were any concerns on the civil side or the criminal side, I think this court's already issued some decisions that pretty much conclusively resolve that there is a substantive right to be immune from suit, immune from prosecution, and immune from civil action. And so I don't see any concerns in terms of the Keck factors and some of this court's case law in that vein. I would briefly address some of the issues that were raised in the comment filed by the Public Defender's Office Association. I think the overarching theme is these appeals, these reviews are already happening. We don't see an outcome here where all of a sudden these things skyrocket because, as Your Honor just pointed out, I mean, review in prohibition really seems to be like the de novo review of the issue already. Again, the concern there was, well, there were some examples, and Snow is one of them, of folks waiting a little longer than 30 or 15 days or so to get that process started. Part of the concern there was certainly issues related to the transcript. Well, again, the committee, felt that creating an interlocutory appeal rule where you can submit your notice of appeal timely and then seek relief from the courts to the extent you need time to get a transcript together, things of that nature, extensions, at least that way, again, it's formalized, it's proceduralized. So that was a concern that we felt was actually addressed by the rule. Again, I've already mentioned, we don't feel like we're asking the court to create a substantive right, a constitutional right, rather, at all. For that reason, that's why, one of the reasons why we proposed the Anders language that says, Anders briefs are not appropriate. Obviously, Anders applies just to your first direct criminal appeal. That's in the case law itself. And that's because that obviously is the constitutional right space. This is not. This is an order that exists before a judgment and sentence. This is essentially a procedural order, perhaps on the way there, but not quite there already. So those same considerations that the court's talking about in Anders, we don't see those as being present. Certainly, it did not seem to make sense to ask reviewing courts to review records that aren't really transmitted, in the sense of, you create your appendix with a non-final appeal, and of course with a writ. So a lot of reasons Anders doesn't really work in this scenario, which is why we made that recommendation.
What is the committee's position on whether there needs to be tolling, automatic tolling with
a stay?
Yes.
The committee's position is that mechanism certainly exists in the rules and can be sought via motion. There's the cross-reference between 9.140 and 9.130, and the reference that, you seek criminal appeals shall proceed as civil appeals except as modified. So our position would be, if there needs to be a stay, it's as if you were in another non-final appeal case. You file the motion and seek review pursuant to that mechanism that's already there. I'll reserve the rest of my time for rebuttal unless there are any other questions.
Thank you.
Good morning, and please the court. John Eddie Morris on behalf of the Florida Public Defender Association. I appreciate the court's attention, and from the court's questions, I know that the court has read and understands our comments. Contrary to the committee's suggestion that the DCA is already reviewing these regularly, quite frankly, you ain't seen nothing yet. If this proposal is accepted, this is a right, and I know the committee disputes that, but a right to appeal can be created by Constitution. Final rights of appeal, and final orders are created by statute. And under the Florida separation of powers, this court creates the right to interlocutory appeals. And what the committee is proposing is for this court to create a right to an interlocutory appeal, which has a lot of implications in the criminal world, because we will need to tell our clients, you have this right. And our clients, as they have said to me many times, is, well, what's the downside of me doing this? And if I say nothing.
How is that analysis any different than the context of prohibition? I mean, don't you have the obligation to advise your client that you have the right to challenge this pursuit of prohibition?
Your Honor, we do not regularly inform our clients of every extraordinary writ they could take. And this is goes to the Chief Justice's point. For instance, every person who's sitting in jail on a bond has if to use Your Honor's suggestion, a right to habeas corpus. We do not suggest to every client that they take a writ.
And why not? Why is an extraordinary writ different? In terms
because
of
I'm sorry.
Just in terms of the client's potential remedies, why would advising on an interlocutory appeal versus an extraordinary writ be any different? Because
it is discretionary. Is the best answer, and the second answer I give is I promise you that is the practice. If this court thinks we should be telling every person who's sitting in jail on a monetary bond that they have a right to habeas corpus, we will take that instruction. But I do not think the court wants to do that.
I don't think the court's in the business of telling attorneys how to advise their clients. I'm just trying to understand the difference.
The court is in the
practically.
business of saying what our ethical duties are, and we take those quite seriously. And
you're talking about something that would happen in every case that you have. You know, your client's in jail. You have an obligation to tell him that you have a right to habeas. He obviously is going to say, well, go for it. But you're talking about just about all your cases, the people who are in custody. How many cases are there involving this stand your ground thing?
Your Honor,
Not as many, I would think.
Just as a point of information, most of our clients are not in jail pending trial, thank God. We try to do a better job for our clients than that. Second, there are a lot of stand your ground motions filed. And what the DCAs are seeing as reviews of that are maybe 100th of the, or less. I mean, it is a minuscule percentage of those.
I think the part of your argument with which I'm not sympathetic with the idea that we are in the rights creating business, and I am not sympathetic to the idea that we are in the direction of what you need to advise your client about business. But without conceding either of those, the part of your argument that I find persuasive is the idea that if there's something new, then there are going to be jailhouse lawyers, there's going to be Google searches, and you're going to have defendants saying, oh, they just changed the rule. I'm just wondering how much of that is just on you as a lawyer and on the defense community, of which I used to be a member, to just say, yeah, that's not what that means.
We can always advise clients. In fact, we obviously would advise a client if we believe that an appeal would be meritless. But as I said, that conversation, and I have had those conversations, and they always go, you know, I don't believe that it's has any merit. I don't believe you're getting relief. And they ask, what's the cost? And I say, nothing to you. There's a huge cost to the system, of course, but nothing to the client. And the decision
I guess that's what I'm pushing on, is I don't understand how it's any more costless than the meritless habeas petition for the detainee. Both are frivolous, and both as counsel, you sort of have a job to say, that's frivolous. That's not going to win us any favor with the judge who might ultimately be sentencing you.
And that's an extraordinary remedy. But where you have a interlocutory appeal, and I believe that is a right. I believe that is a right created by, I mean, that's how the separation of powers works.
To bring a frivolous proceeding, I guess I struggle.
No, Your Honor, the right is the right to bring an interlocutory appeal.
Well, I understand, but if you have no issues and it's frivolous, I understand, and I'm not unsympathetic with the point you're making, but I do struggle with this idea that there's a right to bring a frivolous proceeding, which which everybody knows is frivolous, except and maybe even the defendant knows is frivolous, but doesn't care because it's just something that can be done.
Your Honor, but here's the point: whose decision is it to take an appeal? And the law is pretty clear; it's the client's decision to take an appeal.
Yes, so this is a common argument when anytime whether we're looking at 9.130 or in the criminal context, that if the court creates a mechanism to review these types of orders interlocutory, that there's just going to be this wave of appeals that's never going to end. And I don't know if that historically has happened when the rules are amended. Do you see this as something that there might be like an initial rush when the rule is amended, if it was amended, and then once the class of litigants sees that these are being regularly denied, it slows down? Or do you think this is a permanent situation that the court would create?
I believe it would be similar to what we have with Anders' appeals, which is Anders was decided in the 70s, and I see no end to that wave, Your Honor.
Could you maybe address whether this is a solution in search of a problem? I think my questions for your friend were about how much data is there really out there about this being a remedy that we actually need, and he had some learned things to say about that. Is he right?
No, Your Honor, that was my second point. I essentially have 2 points for the court. One, this is unworkable. Second, this is unnecessary. Let me address that second point. And I think the fact that there's 3 cases, the committee cites 2, I found a third. The fact that there's 3 cases, I think, speaks strongly to the fact that this is not a situation that needs to be handled by a rule change. The courts, the DCAs have shown that they're quite capable of, and the best case is, I think, Lewis, actually, where the court says, you filed this on the eve of trial, and we're not going to hear it because it's a discretionary writ. And I think that that's appropriate. The other cases, Nadell and Snow, both really are struggling with the substantive point of whether prohibition is correct or not. As Justice Kennedy has suggested, this court has said it is. Maybe they don't like it. Maybe it is. Maybe it is an intellectual box, but we certainly have other situations where prohibition is used where a court just simply can't proceed. And I think that is what the writ is about. Whether the DCAs are comfortable with that or not, the key is if this court will leave that in a discretionary posture, then if there are abuses, the DCAs are perfectly capable and willing to deal with it. And to your point, Madam Justice, when the difference between certiorari and prohibition, and sometimes there is a trap there, that is absolutely true. Defense attorneys have just got to be good. And, you know, that's, but the cost, sometimes we see a situation and there's a human nature to say there must be a rule. There ought to be a rule. Not always. Sometimes making a rule makes the situation worse. And this is one of those situations. It makes it unworkable, and it's not necessary. The courts have, with the discretion afforded with an extraordinary writ, they are able to take care of the situation.
Well, I find it very interesting that ordinarily the public defenders want the key to the courthouse, and I don't mean this in a negative way at all, but that you are suggesting that you're happy with the way things are now and don't want this maybe easier key to the courthouse. I take that seriously, and I think that is significant because it's not common for public defenders to say, "Oh, we don't want an additional way to get to court for our clients." So, but that's a way of acknowledging, I think, the weight of your concerns in this context.
Thank you, Your Honor. It truly does go to that. We see this as creating truly enormous problems.
It creates, if I understand you right, the problem it creates is actually an attorney-client problem. It sounds to me like what your position really is, oh my gosh, if you give us this tool, it's going to be really potentially divisive in the attorney-client relationship for us to explain what this tool is and isn't, and it's going to create a source of tension, systematic source of tension. Am I hearing you right?
That is true, and that is, and it is the same tension we have in Anders when we are asked to file an appeal, and we just can't find any merit to it. And I assure you, clients are not very happy when we file an Anders brief.
Yeah.
Here, without an Anders brief, the problem gets worse, and it becomes a stacking problem. If we find there's no merit, and the client is upset, as they will be when we say this to them, we're going to have a conflict. We're going to have to conflict off the case, and subsequent counsel is going to be in the exact same situation, where they're going to look at it, they're going to see it's meritless, and it will be, to borrow a phrase, turtles all the way down. That is a very serious problem. I mean, Anders works because we get to withdraw at the end of the final appeal. And that's essentially our goodbye handshake to the client. I'm sorry I can't do anything for you. you're on your own. We can't do that in an interlocutory appeal context. That's just a different scenario and situation, and it does, so it creates, and it's sort of this built-in attorney-client conflict that does not need to happen. It does not happen with extraordinary remedies.
Think of another situation as directed.
Your Honor, I believe this court has allowed enters in. No, I think the answer to your question, the Honor's question, is no. I was thinking of the when they remove a child from a parent case.
Termination.
Yeah.
Thank you. I don't practice in that area, and I couldn't remember the term.
TPR.
But that is also a final order, I believe. Although I should not speak about law I know nothing about. I will leave that to those who actually know that area of law. I'm going to retract all my comments on that. Are there any other questions from the court?
Just our thanks for doing the thankless, both of you.
Thank you, Your Honor. We greatly appreciate it, and as counsel said, we greatly appreciate not having to fly into the middle of that hurricane. It was quite worrisome. Thank you so much.
Thank you.
Thank you. Well, if you'd like to hear from me further, in terms of a data point, I think an interesting one is that this is the second referral in 2018. This came to the committee. The committee looked at it. We didn't recommend any change at that time because it wasn't the right time, perhaps. Immediately, after we don't do that, these next two cases come up and they're struggling with it and they're writing on it and they're referring it.
I mean, come on. Just because some DCA judge has, wants to whip out the dusty books and look into, what prohibition and this and that. I mean, this is an area where clarity is all that you need. And once you know that it's available and the people get substantive access to what they need and the system, isn't overburdened with unnecessary things. I mean, you would think that it has credibility to me that people who you would expect to be wanting every opportunity are saying this would actually make things worse. I mean,
I certainly wouldn't dispute that. The issue, from the committee's perspective, I can tell you, we sort of thought, well, that seems to be something that would really matter more at the trial court level, bringing the motion in the first place. We're talking about a review mechanism here, and one that, frankly, sort of already exists. The decision about whether to bring that motion in the first place, that's probably the bigger decision when you're talking with your client. I certainly wouldn't speak to that, but that was certainly something the committee considered in grappling with this problem.
Can you remind me, in the 2018 referral, I don't remember seeing where was that referral from? Was it from the criminal attorneys or was it from the DCA? Or
I want to say that was from the DCA, Your Honor, but I wouldn't be able to feel confident with that answer. I apologize.
No worries, thank you.
I can certainly tell you we sort of looked back into it when we got this new one on our desk to refresh our memories. I mean, if there are any further questions, I'm happy to answer them, but I think we've talked about this one. Thank you, Your Honor.
Thanks so much. We appreciate it. Okay, our next case is JJJTB versus Schmidt, number 2023-0915.
May it please the court, Daniel Nordby from Schutz & Bowen on behalf of the petitioner. This case involves a question that has divided the district courts. Is a party's objection to case jurisdiction waived if not timely asserted? This court should quash the second district's decision and approve the district court decisions distinguishing between case jurisdiction and subject matter jurisdiction and finding objections to the former to be waivable. Unless the court would prefer otherwise, I'll begin by addressing the differences between subject matter jurisdiction and case jurisdiction.
Can we focus on the timeliness aspect? So, because I'm a little concerned with how an outcome in this case fits in within the overall jurisprudence in Florida. And there's several district court cases. I think the brief highlights, I know you didn't write the brief, but the brief highlights that these deficiencies in case jurisdiction renders a judgment voidable versus void. There's a lot of district court precedent saying that whether or not a judgment is voidable can be raised on rehearing. And I'm not sure if that's correct or not, but can you explain why whether or not something is voidable should not be able to be raised for the first time on rehearing?
Sure, I'd be glad to. So I think the point with requiring a timely objection to this goes to the general principle in the case law about avoiding unnecessary judicial proceedings. So in the case of personal jurisdiction, for example, that objection must be raised at the earliest opportunity. Here, too, that objection can and should have been raised much earlier than a motion for rehearing or reconsideration, rather than 2 years into the case. Whereas in this case, this case did not involve a situation where case jurisdiction came and went, as it does, as you said, in some cases. This is a situation where an objection to case jurisdiction was available to the respondent from the time the motion to amend the complaint was first filed. So in this particular case, there would have been no impediment to the filing of that objection at that earlier.
Not just that, but it also seems to me that you have a little bit of they have a little bit of a round peg, square hole problem in that a motion for rehearing is largely about directing the court to things the court overlooked, not things the parties overlooked.
Well, I certainly agree with that. And of course, in this particular motion for reconsideration, there was no objection to case jurisdiction. There's a 2-paragraph objection to subject matter jurisdiction. The second district, I think, got that issue right. The second district said there is subject matter jurisdiction here. Subject matter jurisdiction refers just to the court's power to deal with a class of cases to which a particular case belongs. There's no question that circuit courts in the state have subject matter jurisdiction to address foreclosure cases. So this is not a subject matter jurisdiction case. Subject matter jurisdiction arises from the Florida Constitution, from authorized statutes, and does not depend on procedural issues. This court in its Cunningham case said, for example, the circuit court had subject matter jurisdiction over bad faith claims against insurance companies. There may be some procedural impediment to the court's exercise of that subject matter jurisdiction, but that's what case jurisdiction is. Case jurisdiction involves the exercise of jurisdiction, not its existence.
Can you help us, and I know it's not necessarily relevant to the legal issue, but help us understand how, I don't know what the bigger sort of travesty here is objecting to something 2 years into the litigation, or your client showing up 2 years after an appeal has been decided and closing out a case and then filing a motion to amend a complaint. I mean, what good faith basis did anyone think on either side for thinking that this case could kind of be revived in this posture?
Sure. So I'll address it to the extent I can from the record here, not their case, but our case. If you look at the docket entries for the trial court in this case, it's the beginning of the record, you'll see that even after the initial final order, which may or may not have been final, was appealed, the mandate came down after it was PCA'd. You'll see there continued to be extensive docket activity in 2017, 2018. The trial judge issued an order calling for a case management conference. The order was in August of 2018, setting a case management conference for October of 2018. Shortly before that case management conference, my client filed a motion to amend its complaint, And that motion was heard at the case management conference, and an order was issued accepting that.
Was the motion to amend the complaint because of a subsequent default, or was it for some other reason?
It was because of a subsequent default. Now, the first amended complaint had 2 counts. One was an action on the note based on subsequent defaults, and then the other was an action to foreclose the mortgage based on the subsequent defaults.
But both relate to the substantive default. I guess it was 2015 or 2016, not the a priori thing that got you to the first, order, whatever its status was.
That's right. So the motion to dismiss the first amended complaint attacked the action on the note and alleged that it fell outside the statute of limitations. I think it's reasonable to infer that the petitioner here filed the amended complaint in an effort to have that relate back to the filing of the initial complaint to avoid that statute of limitations issue. The statute of limitations issue isn't there on the action on foreclosure. So that was the subject of the second amended complaint, an action for foreclosure, which is not barred by the statute of limitations. So that case went forward on the foreclosure note for 2.5 years, a 3-day bench trial, an answer, and 18 affirmative defenses filed by the respondent, none of which addressed jurisdiction of any sort.
But can you go back? So after the appeal, though, I understand the argument about the language of the initial quote-unquote final order and how that maybe raises an issue as to finality. But what, after the appeal, and then you said there was docket activity, I mean, what would have led what could there have been that, if you assume that it was a final order and that the second DCA did its thing, I mean, what could there have been still left going on?
So I will candidly acknowledge perhaps the better procedure here would have been to file a new action to foreclose the mortgage based on the subsequent defaults here. There was an attempt to do that in Polk County, and then based on the trial court's order there from Judge Comby over there, this action took place when there was a case management conference set in the original case, an effort to amend that. The issue, and to go to your earlier question, Chief, is that had this objection to case jurisdiction been raised at that time in response to the motion for leave to amend the complaint, and had the trial judge ruled on it there and said, the mandate's issued, I can't do anything more, this case is closed, my client in 2018, 6 years ago, could have filed that complaint for foreclosure and pursued it to its resolution. Instead, what we've had here is all of these years of litigating, not raising the issue, consumption of resources of the parties and the court to get to the same place. I mean, my client now, if it had to, could still file this motion or a complaint to foreclose this mortgage, because that, if this court were to rule against us, our position is that it should not need to do so, because the respondent could have raised that issue but failed to do so.
So in terms of whether this is, conflict, certified conflict or express and direct, do you see this as similar to, was it MCR funding, in the sense that because the case jurisdiction really came up for the first time on appeal, and the objection that was raised in response or in the motion for rehearing was the subject matter jurisdiction, this is really more of express and directed, and it is kind of associated with MCR, or do you see it differently? So
this court accepted jurisdiction on both express and direct and on the certified conflict. We do think there's conflict with MCR funding out of the 4th District and the Schroeder decision out of the 4th District. As I said at the outset, the district courts are divided on this issue. I would say, broadly speaking, the 4th and the 6th are with us. The 2nd and the 1st are with them. And the 3rd and the 5th are kind of a mixed bag, candidly. The 3rd District, we've cited the Ocean Bank case, which we believe from the 3rd, which we believe involves a similar situation and is consistent with our view of it. But this goes to the larger point that this is an issue crying out for this court's clarification, not because the district courts are struggling, but simply because they are arriving at different conclusions on the same question, and it's an issue that has recurred. Well,
I think in the 3rd DC, I don't have it in front of me, but I know that they have the you can't raise avoidable judgment on appeal for the first time. But I think they might fall into the category of districts that say that you can raise avoidable judgment on rehearing. And so I think it's important for us to be clear on what we're doing, whether we're saying that it was late raised because it was raised in rehearing, or whether it was an issue that's raised from the first time of appeal, because those are treated differently in the district courts. I'm just trying to get your impression of where this exactly falls in this.
Understood. I think the better view of it would be that this sort of objection should be raised at the first opportunity that's presented. The third district said in the Sanchez case, acknowledged that it had used the terms case jurisdiction and subject matter jurisdiction, quote, interchangeably and at times improperly. So I think this is an issue that has confused some of the courts below, and they've come to different conclusions on the same question, which is why we're asking for this court to bring some clarity to it. But to directly answer your question, if there is an issue that would render a judgment voidable, that objection should be raised at the first opportunity. As this court said in State versus King, there's good reason for requiring defendants to register their objections with the trial court at the first opportunity. It said neither the common law nor our statutes favor allowing a defendant to use the resources of the court and then wait until the last minute to unravel the whole proceeding.
But when you say should, I mean, that sort of sounds like doesn't lend itself to kind of a categorical rule. I mean, you could imagine there being different types of things that might be voidable, and then it gets raised in rehearing, and the court kind of says, in this particular case, you're too late. In this other case, you're not too late. I mean, because it's must be versus should be. I mean, it seems like that's a separate issue, is what do you have to do to waive, as opposed to is it waivable? And then, you know.
But in the underlying point here, though, that relevant to this issue, that they did not, in the motion for rehearing, raise case jurisdiction. They raised subject matter jurisdiction.
They did. The first mention of case jurisdiction was in their reply brief in the second DCA. That's right. So
this is really not the business about the rehearing. Why is it relevant if they did not raise? They didn't even raise the issue then.
I'd agree this may be an easier case than some of the other cases that come up. Where this frequently comes up, based on the cases we've cited, is in actions to enforce a settlement agreement, where the parties settle a case, dismiss it, and then one or both of them go back into the same court case number for an action to enforce that settlement agreement. That presents, I think, an easy case where if someone invokes the jurisdiction of the court and the other side does not object and they actively litigate the case before the court, then they've waived any objection to that court's case jurisdiction to adjudicate the decision, because the contrary decision would allow them to lie in wait, to litigate the case, find out whether they're going to win or lose, and then if they lose on a motion for rehearing or reconsideration, say, never mind, now that I've lost, you have no case jurisdiction, I can raise it at this point. Some courts would say you can even raise it on appeal and undo that whole proceeding. That's inconsistent with the use of the court's resources and the party's resources, and it's something that the fourth DCA got right on this. And Judge Ray, in her concurring opinion from the first district, in the has a long case number, I'll call it the San Pablo case, explained this difference and the difference between void and voidable judgments, and why an objection to case jurisdiction, sometimes called procedural jurisdiction or continuing jurisdiction, should be voidable rather than void.
Does the waiver issue matter at all, that essentially, like, the procedural rules are the court's limitation on its own discretion on when it's going to hear a case? Think of notice of appeal, for example, being 30 days instead of 60. Does it matter that it's the court's pronouncement of when it will hear a case versus a party's right, like in the way that asserting a defense would be, in terms of relinquishment of a known right, intentional relinquishment, if we think of the definition of waiver?
It's a good question. I think this falls more in the category of a right that the party has in this case than the court's authority deriving from the Constitution and statutes. That's the reason that subject matter jurisdiction is not waivable and always leads to a void judgment and can be raised at any time, because it involves the court's very authority to act in any kind of case, rather than just under this particular facts and circumstances presented. Under the circumstances where a party subjects itself to the court's jurisdiction without objection, asks the court for affirmative relief, That I think falls in line with the sort of procedural issues that a party would need to object to at the earliest opportunity. I look at, again, State versus King from this court, where a juvenile was charged by indictment rather than by an information, and this court said that's a procedural issue. You have to raise that at the earlier opportunity. You can't raise that at a later time and call it subject matter jurisdiction. And this court has held similarly in cases going back to the 1920s. The contrary cases, the cases that my friend on the other side is pointing to, in many cases confuse these two distinct concepts. They refer to a court lacking jurisdiction to act, rather than being more precise and talking about whether it is subject matter jurisdiction or case jurisdiction. The second district, as I said, has acknowledged that these two are different things, but as a matter of district precedent has said that neither are waivable. The first district has said the same thing in the opinion from Judge Ray that I mentioned. It's acknowledged the difference between them, but it said that they are both not waivable in that case.
But I mean, in some sense, I mean, I agree that there's the distinction, but and they may be clearly established, but they can still be, you could still say that it's kind of an arbitrary distinction. I mean, if the order was final and the appeal was final and the mandate issued, the court doesn't have the quote unquote authority to hear that particular case at that point. And essentially through this waiver, the parties kind of gave it the authority to, which is sort of a conceptually kind of, I mean, so we're basically just kind of saying that, you know, given the landscape and the precedents that we're going to kind of overlook that. But I don't know that just sort of through this labeling exercise of subject versus case, I mean, you still have the fundamental problem that in this particular case, if everybody was playing by the rules, the court didn't have the authority to act.
I agree the court did not have, I agree in a case where the court lacks case jurisdiction, if an objection is timely raised to that.
And we're sort of operating, I mean, this whole thing is about trying to figure out in that situation, can it be cured through this waiver? I mean, that's
agreed, and I distinguish that from a circumstance where a party filed a complaint for foreclosure of a mortgage in this court. This court does not have subject matter jurisdiction to adjudicate that type of case, no matter if the parties wanted this court to decide that case or not. I see my time is running low. I'll reserve the rest for rebuttal. Thank you.
Good morning. If it pleases the court, my name is Jesse Ray. I'm here on behalf of Schmidt and Schmidt Farms, the respondents in this case. Today we're here on the question of case jurisdiction and how it will be decided in Florida. Everyone agrees that this case doesn't involve subject matter jurisdiction. Everyone agrees it doesn't involve personal jurisdiction. Florida has held that case jurisdiction is very fact specific. The facts of this case briefly: there was a 2011 foreclosure with a 2015 trial in Hillsborough. There was a final order for defendant against JJGTB. So the defendant had won that foreclosure. It was final in every respect in the sense that there was no additional judicial labor that was left to do, and it was appealed as a final order to the second DCA. JJJTB appealed that, and the court per curiam affirmed it and issued a mandate resending that case back to the trial court. There was no reservations in the mandate with regard to amending the pleadings. 2 years later, after having filed a case in Polk County, JJJ came back and sought leave to amend in the original Hillsborough case. The court allowed it, and we ultimately had a trial where JJJTB prevailed. At that point, the respondents had filed a motion for a rehearing. Schmidt made jurisdictional arguments that were denied, and it went to the second DCA. While we specifically didn't use the technical magic word, case jurisdiction, we did lay out the facts of this was a final judgment, and there was a mandate, and that there was no reservations left.
And then there was an alleged subsequent default, though. I mean, I feel like you can't really bury that, right? Perhaps this line of argument would have a happier conclusion for you if the amended complaint were about the 2011 default. But how do you address the fact that, you know, for me, this case sort of restarts with that second default, and it is also the case that it is less about case jurisdiction and more about the nature of waiver. Help me understand how your case jurisdiction argument is so fundamental that it is unwaivable in light of that second default.
I would say that it has to do with the finality of the decision and the mandate, Your Honor.
Well, yeah, but there's a new default. There's a fresh default. There's a new. I mean, according to your friend and according to the other side, you default on the note again, right? You stop paying, or whatever the nature of the default is.
If they had filed a new fresh foreclosure, that would have been a separate, different case. There would not have been any of these issues that would have been raised in that case. As far as what is the policy, as the issue.
That's a purely formalistic way of looking at this, as opposed to looking at the merits. And I understand we do look at things formalistically, and that's not alien to our task, but not always. So I struggle on the merits of it.
The merits of it, again, the policy of finality, and I would point to the court's decision in Dober versus Warhol.
Well, but you know, on the policy of finality, you can litigate something, and the judgment can be final and can have res judicata effect, and then somebody can go, one of the losing party can go into court and try to relitigate it again, and if you don't defend on the basis of res judicata, you have the benefit of that, and you don't bring it up, it is waived, I think, under our law. And if you can get, because you know people have to bring up their issues, they have to bring up their defenses, and if they don't, then the ship has sailed, and so I'm struggling to see why this is different than someone who failed to bring up a res judicata defense, who would lose the ability to raise it in the appellate court if they failed to bring it up at the first opportunity in the trial court.
Again, Your Honor, like in a fact-specific test, whenever the case law would have to do with the finality of the test, that this would affect whether or not the case has been waivable. And again, I feel that this was in the Dober v. Warhol case, the Supreme Court specifically held, it is our view that a procedure which allows an appellate court to rule in the merits of the trial court judgment and then permit the losing party to amend its initial pleading to assert matters not previously raised renders a mockery of the finality concept of our system of judgment. In none of the cases that that have been cited throughout the court precedent involve this issue of a final judgment that was affirmed on appeal and there was a mandate to the trial court. So even if this is a fact-specific question of the finality policy with regard to the end of this case, without the ability, if this is an issue of waiver, the slippery slope argument here would be where the finality in a case would be, in a case where there's a final judgment and a mandate, the finality would still be a matter of consent, agreement, or waiver. So you run the risk of basically never-ending litigation.
Well, depending on how good the attorney is.
Sorry?
I mean, depending how good the attorney is.
Or depending on whether or not there were two judges in this case that didn't catch this issue either.
Well, that's an issue of when can a judge raise something sua sponte. So maybe can I ask you a question on that? Because typically we think of issues that judge raise sua sponte as those involving judicial power. Here, that would be subject matter jurisdiction. We don't have the power under the Constitution to decide stuff that is not invested to us either through the Constitution or through statutes if authorized by the Constitution. And so then we are authorized to raise those issues sua sponte. We have the obligation to look at our subject matter jurisdiction. When you think about procedural jurisdiction or case jurisdiction, it's within the court's power. We've kind of, not arbitrarily, but as a matter of policy, limited when we hear appeals, when judgments are final, et cetera, but we have the judicial power to hear those cases. And so why would it be appropriate for a judge to raise it sua sponte if it is something that the court has the power to hear and it's incumbent on the parties to then raise to the judge?
I would say that case jurisdiction, it is as the application of subject matter jurisdiction within a certain case, as such that they are sort of bound together and they would be similar in that respect. So because subject matter jurisdiction is the category to hear any case, and then case jurisdiction is within that jurisdiction to hear a particular case, the subject matter jurisdiction and case jurisdiction are similar in that respect, and that's why they can be raised by the court.
So your rule would be anything that affects the court's authority, whether it's the what type of case or the when issue, a judge would be justified in raising sua sponte.
Yes.
Well, and if there's been a mandate, does the trial court have the power to keep litigating the case? I don't know that the premise is right.
But that's exactly what happened in this case.
I know. Well, that's what but I'm just saying. Do you? I mean, isn't that part of the answer to that? It's not just a matter. And that's where it's potentially subject matter, and after a mandate, maybe I don't know that. I understand that we've labeled the things differently, but if the court doesn't have authority after a mandate, then it is a matter of power. It's just not. It's not a discretionary thing, but.
I agree.
So, but is it true though that if you were to win, the other side could come in with the subsequent case? I understand there's a difference between statute of limitations on the note versus foreclosure. Would it be a complete redo of what happened, or would there be certain claims that could be on the table and some of what was decided here?
They're continuing defaults that were alleged involved insurance, and.
I'm sorry.
The defaults that were alleged in the second case involved taxes and insurance. The mortgage incorporates a note, but the note is barred by the statute of limitations. So the taxes are current, and there's insurance on the place right now. So I don't think the mortgage is still enforceable, but if it is, it's not in default.
Actually, you brought up the magic words argument earlier. And the motion for rehearing, if it says explicitly subject matter jurisdiction, isn't that a very different legal argument and not a magic words sort of situation? I mean, we have cases where, for example, somebody has discussed the facts of why they're objecting to evidence, but they used, maybe golden rule instead of unfairly prejudicial or something like that. And those are different arguments, different legal arguments that we hold parties accountable for. So why is this a magic word situation and not a wrong legal argument?
Again, with the issue that this involving the power of the court and having a mandate, that this wouldn't be an issue where the party should be able to waive that and restart the litigation again. So we would say that that would be, I guess, my answer.
So could this be raised for the first time on appeal? Is that essentially your argument? It doesn't really matter what was in the rehearing because your argument ultimately is can't be waived ever, so it can be raised on appeal for the first time.
The second DCA is clearly and absolutely, like the Schmidt decision is absolutely clearly correct under second DCA precedent, and there's a conflict between the cases. So I would say that we would ask that the court affirm the second DCA. To the extent that the court is not willing to say that it can never be raised in any circumstances, we have the circumstance here where we have the final judgment, the appeal, and the mandate, which we think should not be a situation where it could have been waived. And then the second district called our motion for rehearing. They said that it was a challenge under case jurisdiction even without the magic words. So we got the recognition for the legal argument in the decision itself.
Yeah, but putting aside this issue about the rehearing, how did your argument reconcile with the? How can it be reconciled with the provision of Florida Rule of Civil Procedure 1.140H? That says a party waives all defenses and objections that the party does not present either by motion or if the party has made a no motion in a response of pleading, except the defense of lack of jurisdiction of the subject matter may be raised at any time. Again, that seems to state a principle that cuts against what you're arguing.
It doesn't specifically say case jurisdiction in the rule. And again, I would say as a subset of case jurisdiction.
Well, it says anything except subject matter jurisdiction, and you started off by saying everybody agrees that this is not about subject matter jurisdiction or personal jurisdiction. So it really covers the waterfront, carving out the subject matter jurisdiction, which may be raised at every time, but everything else you got to bring up, and if you don't, it is waived.
I would say the case jurisdiction is a subset and a subspecies of subject matter jurisdiction.
Well, that's a very odd thing to say now. I mean, maybe my memory's failing me, but I think you said you accepted this.
It is.
Again, I understand you've got the case you've got, okay, and you're doing the best you can with what you've got. But I thought I remembered you kind of accepting this tripartite division between subject matter, personal jurisdiction, and case jurisdiction.
I agree.
And now you're kind of moving away from that.
I agree that they're generally recognized as three different things. I recognize that the rule says what it says. I don't think that the interpretation of whether or not subject matter jurisdiction includes case jurisdiction under certain circumstances fits under that rule was the same determination as whether or not Florida courts have recognized three different types of jurisdiction. Does that answer or address your question? Okay. Again, under the precedent of the Dober case, with the slippery slope being if this court issued a mandate and it said that this could be waivable at any time, there's a risk that we could go back to the trial court and get leave to amend and be off and running yet again. There were two judges that missed this case. Judge Isom is the one who granted the leave to amend, and of course Judge Peacock was the judge on the case for the rehearing in the trial. But again, we would ask that either the court support the second DCA under the principles of finality, or if to the extent that the court finds that this is waivable under certain circumstances, that in these circumstances with the final judgment that was final in all the respects, the appeal and the mandate, that this would not be a situation where it should be waived. And it was raised in the rehearing. The second DCA recognized that to the extent that that prevents it from being an express conflict. And if not, then it's just an issue of whether or not the second DCA or the fourth DCA, whose rule of law rules the day. Thank you.
Thank you very much.
Morning. Very briefly, we agree that the mandate rendered the initial decision final as to the initial defaults. What we're talking about here are new instances of default. As to the issue of post-mandate action by the trial court in this proceeding, that goes to the court's authority to act as a matter of case jurisdiction in precisely the same way we would submit as a trial court that acts after the parties have voluntarily dismissed a case pursuant to a settlement agreement. And we've cited several cases where the parties have dismissed a case pursuant to a settlement agreement. The court has not reserved jurisdiction to enforce that settlement or entered an order retaining its authority to enforce the settlement, and then the parties go back before that same court to seek enforcement of the settlement agreement. And cases, the Clark case from the 6th DCA and other cases that we've cited too, say in that instance when the parties have gone into a court that perhaps there is a valid objection to case jurisdiction if timely asserted, but if not asserted, where the parties have subjected.
I guess the wrinkle, and I don't know that it matters, but it does seem different. I mean, in that sense, the offense is just, it's, yes, the court, you know, the court shouldn't be acting on it. It seems like the mandate, it does implicate sort of the authority of, you know, the appellate court and that whole process. Because, you know, if you have a judge who doesn't like the result in the DCA, and then you have a party that obviously didn't like it, and then you have the other party on the other side sort of sleeps on the issue. I mean, you could really imagine a situation where kind of the appellate court's authority is undermined, whereas in the instance of the dismissal and they come back, I mean, it doesn't have that aspect to it.
Well, I take your point, and in a different case, if my client here attempted to amend its complaint to reallege an action based on the initial defaults. That would clearly undermine the authority of the appellate court to finally decide that issue. The fact that these are new defaults and it's an amended complaint that could have been brought as an independent action without any res judicata effects, I think takes it outside of that scenario.
But in terms of just the underlying legal principles that you're talking about, that case too, that would still be, we'd still be in the same boat. I mean, we may have more of an incentive to figure out a way that you would lose, but the underlying, the bottom line, the principles would still be the same. The whether it's waivable, whether there's this real distinction, but meaningful distinction in this context between case and subject matter, et cetera, et cetera.
I take your point. I think that case would raise some different issues than the ones here. And certainly we cited at page 13 of our brief, Rule 1.140. To Justice Candy's point, we think that distinction in that rule between subject matter jurisdiction and all other defenses reasonably applies here. And in my last 3 seconds, if I could, to go back to...
I had the question, so.
Okay.
The Chief doesn't mind.
I'll let you... I was going to your earlier question, but I'd be happy to hear your new question first.
Oh, no, go ahead.
No, go ahead.
I was just going to point to pages 21 and 22 of our initial brief in response to your earlier question about when these objections should be raised and why they should be raised at the first opportunity.
My question is just on the sua sponte aspect of the trial court judge would have been justified here in raising it, or authorized, I guess, rather than justified.
I don't think so. Is my hesitant answer on that? That a trial judge would certainly have the ability to sua sponte and maybe the obligation question her subject matter jurisdiction. But if this is in the nature of a procedural defense that a party may raise, then party presentation principles would suggest that maybe the judge shouldn't raise that issue as a potential defense for the one party. Not an issue we briefed, but that's my best answer here.
Anybody have any other questions?
All right. Thank you very much. We'd ask the court to quash the second district's decision, approve the conflict cases, and hold that the respondents failed to timely assert an objection to case jurisdiction and remand it to the trial court. Thank you.
Thank you very much. We'll be in recess for 10 minutes.
All rise. All rise. Florida Supreme Court is now in session. Please be seated.
Okay, our next case is Hunt versus State of Florida, 2024-0096.
Thank you, Your Honors. May it please the Court. Barbara Basharis, representing Mr. Hunt. I'd like to reserve 5 minutes of my time. Thank you. Your Honors, this case does present some constitutional issues about the current sentencing law, but I would like to begin briefly with the issue of the inextricably intertwined evidence, so-called, or evidence of motive that was presented at Mr. Hunt's trial that exceeded the scope of relevancy and created undue prejudice because he challenges his conviction on that basis, not just his sentence. The evidence in question was first put in issue by a notice of similar fact evidence that the state filed, referring to alleged actions beginning in early 2018 and continuing up through the date of the charged offense. And the state said that they were necessary to explain the context of the crime. The state basically agreed, and the defense agreed in a pretrial hearing, that although it had filed a notice of similar fact evidence, the acts were not similar facts, but they were inextricably intertwined evidence. The problem with that is that inextricably intertwined evidence is evidence that is necessary to explain the crime. It is not just evidence that is background description of the relationship between the parties, and it can exceed the scope of relevancy when it goes too far afield of what's necessary to explain the crime.
Doesn't it go squarely to motive?
Absolutely, Your Honor. And the evidence that was properly admitted went to motive. That was evidence that Mr. Hunt was in court, that that he was told that there might be an active warrant against him. I believe it's in the record that the warrant was described as one involving an alleged sexual battery of a minor, and that he left court. The state's entire theory of motive was based on his knowledge of that warrant. And so facts relating to that were necessary to explain motive. What wasn't necessary was over a year of description of other activities that had nothing to do with that warrant.
Let's double click then on the word necessary, because I think you're using the meaning of the word necessary to mean indispensable, which is one meaning of the word. But in the context of determining whether or not evidence is relevant, there is a different meaning of the word necessary that we generally apply, which is that it tends to make a fact at issue more or less true. It is necessary to prove it in the sense that it is useful to prove it. It is supportive of it. Can you direct us to a case where we've said that necessary means what you say rather than what I'm describing?
I can't think of that exact phrasing at the moment, Your Honor. But one of the cases that we cited, which was Wright, talks about the necessity of a significant link in time and circumstance, and that's one of the ways that this court and the lower courts have drawn a line around what is actually necessary to describe a charged offense versus what is simply evidence that describes other alleged bad acts of the defendant and puts the defendant in a bad light. And so here there was no significant link in time and circumstance between all of the alleged descriptions of trafficking, prostitution, and the warrant for which that allegedly supplied the motive for the charged offense.
Your argument is essentially that it went too far.
Yes, yes. Again, not the defense agreed at trial, and I'm not arguing that there was no relevancy to the fact that PO had made allegations against Mr. Hunt. That went to the state's theory of motive. But going into his relationship with her, his relationship with Ms. West, his alleged batteries on Ms. West, involvement in prostitution, traveling back and forth to Mississippi and New Orleans from Florida, all of that was evidence that was not necessary or linked to the state's theory of motive. But what it did do was succeeded in portraying, Mr. Hunt as somebody who was engaged in a variety of criminal activities for which he wasn't charged in this case.
In context, what do we make of the fact that it was 6 of 29 witnesses that mentioned it? It's mentioned briefly in opening, closing argument briefly. In context and in terms of reversible error, how should we think about those facts?
The fact that it was mentioned that frequently, Your Honor, and that it was mentioned to open and close the state's case, and that the significant witnesses in the case talked about that. You had P.O., her boyfriend Gabriel White, Ms. West. All were questioned about these back and forth movements between Mississippi and New Orleans. So it's not enough to say that it was only this number of witnesses, because some of the witnesses were just investigative witnesses who would not have said anything about that period of time. They were people who testified about their investigation of the shooting. But of the main characters in the story, they all testified about that period of time. And so I would say based on that the evidence became a feature of the state's case. The evidence of again, the traveling back and forth to Mississippi and New Orleans, the alleged trafficking of P.O., and the other acts on Ms. West. So they exceeded what was relevant to prove the charged offense, and so created reversible error. If there are no other further questions on that, I'd like to move on to the ex post facto issue and talk about why applying the 8-4 amendments to Mr. Hunt creates an ex post facto violation. United States Supreme Court case law, going all the way back to Calder, of course, but then including cases like Daubert, Weaver, Miller, Collins, all of them make clear that if a law subjects a defendant to more punishment than he would have been subjected to when he committed his offense, that creates an ex post facto violation.
You want to explain how you see this as punishment versus a procedure to enforce the punishment?
Because Mr. Hunt was sentenced based on a 10-2 recommendation. The jury did not vote unanimously for death. So under the previous iteration of the statute that was in effect from, I believe, 2016 to 2023, he would have been entitled to a unanimous determination or a recommendation, and he would not have been sentenced to death. The court would not have had that liberty. And in that sense, it's analogous to what we see in some of the other ex post facto cases involving sentencing, where you have a range, for example, and that range is changed by changes in sentencing guidelines. The fact that the ultimate or maximum punishment for a particular crime hasn't changed isn't determinative of whether there's an ex post facto violation. What determines that is whether this defendant or a defendant can say that he and those similarly situated are being punished more harshly than they would have if the law had not changed. And there's simply no question that an 8-4 vote results in more sentences of death, more recommendations of death, than a unanimous vote. That's why the legislature changed the law, because the legislature was unhappy with the result of a case where not enough people voted for death. And so the legislature eliminated the possibility that 1, 2, 3, or even 4 jurors on a carefully selected death-qualified jury could basically prevent death from being the recommendation by disagreeing that that was the proper punishment. So it's not a question. I know there are some cases that talk about use language like there's no ex post facto violation because this didn't change the quantum of punishment attached to this offense. Well, if you just stop with that formulation, Your Honors, then no capital case would ever involve an ex post facto violation, because death is death. We can't raise that quantum of punishment. So if that's your standard, there will never be an ex post facto violation in a capital case.
Well, where do you stop the rule on the opposite end? So I think you've argued that because of this procedural change that there will be more sentences imposed. I could see that same argument presented, maybe an exception, a hearsay exception for a child victim or something. So where is the line between, typically the procedural is not ex post facto and the quantum of punishment is ex post facto?
Mm-hmm. The difference there, Your Honor, is that, say, a change in a hearsay exception would still be applied in the context of an entire trial, where presumably rules of evidence would still apply. There would still be safeguards in place leading to the conviction, such that the conviction would comply with due process. Here, removing unanimity from the death recommendation, which was done specifically to lead to more death recommendations, is not something that can be remedied in any other way.
What about, so the test articulated by the U.S. Supreme Court in Lentz versus Mathis doesn't just end with the fact that it must disadvantage the offender affected by it, but it's specific. The nature of the disadvantage must be, and I'm quoting, by altering the definition of criminal conduct, not at issue here, or increasing the punishment for the crime.
Yes.
It's specific about the nature of disadvantage.
Mm-hmm.
How has this change increased the punishment for the crime?
Well, Your Honor, as in Lentz, where the issue was overcrowding credits and whether somebody would lose those credits retroactively, this change in the law increases the punishment to which Mr. Hunt is being subjected. If he had been... How did
it increase the punishment for the crime?
Well, and that goes back to what I was just saying.
The punishment for the crime in a capital case is death. Yeah.
That's right. And if you end there, then there can never be an ex post facto violation for a capital case, because death is always...
Is your argument that the U.S. Supreme Court was not aware of that when it issued Lentz in 1997?
My argument is when it decided Lentz, it didn't stop with what is the ultimate theoretical punishment for this defendant's crime. It looked at that particular defendant and whether he would serve more time in prison as a result of a retroactive change in the law. And that's what the ex post facto violation is. You can't just stop with, well, this didn't increase the ultimate penalty for an offense that can be punished by death. But what's important to remember there, Your Honor, is that that same offense is always punishable by life. The law is always satisfied with a life sentence. Jurors are even instructed that no matter what else they hear, nothing compels them to vote for death. And so life is always an acceptable sentence under the law. What this removal of unanimity does is it makes it more likely that a death recommendation will be in place that will shift the punishment from life to death. And that is the increase in the punishment that creates the ex post facto violation.
It sounds like it's an increase in the likelihood of a certain already prescribed punishment.
It is an increase in the likelihood that a particular theoretical punishment will be applied to an actual defendant. Yes, so just as in the cases, the U.S. Supreme Court cases involving sentencing guidelines, involving reduction in gain time credits, all of those cases involve defendants with a sentence for a particular crime. In all of those cases, you can look at the defendants and say they were sentenced of this crime, and here's the penalty for this crime. But the ex post facto violation came about because what the legislature did increased the time that those defendants would serve, and did it after the date of the defendant's offense. This is a separate argument, of course, from whether unanimity is or should be constitutionally required. I briefed that separately in the brief. In this argument, we're talking about that window of defendants whose offenses were committed after Florida added unanimity to its statute and before the legislature removed it. So there's about a 7-year window during which unanimity was the law of Florida. And those defendants are at risk, and Mr. Hunt isn't just at risk, it's already happened, of being sentenced to death when, under the law in place at the time of his offense, he could not have been sentenced to death based on the same recommendation. Yes, Your Honor.
If you don't mind, I want to, if we could pivot a little bit to Ramos.
Yes.
So, you sort of make the same argument in a slightly different way. I'm wondering if the fact that Ramos, which is obviously subsequent to Lentz and is recent, the fact that Ramos doesn't seem to have clarified the issue that you're arguing doesn't foreclose the argument you're making. And I wonder if you could maybe just elaborate a little bit on the point you make at page 62 of your brief about Ramos.
Your Honor, I believe the importance of Ramos, at least for this part of my argument, is that Ramos recognizes the effect and the value of unanimity in jury deliberations. And so it also recognizes that removing unanimity is a way of silencing dissenting voices. And so for that reason, there's a difference between an 8-4 vote and an 8-person unanimous jury.
Well, I mean, okay, let's start at the beginning, though. Ramos is about a non-unanimous vote to convict.
To convict, yes.
Okay. Why doesn't that sort of distinction between that case and this discussion sort of, I don't know, limit the force of your argument? Can you tell me, isn't that sort of a big deal?
For this part of the argument, Your Honor, I don't think so. And it's because of the way Ramos recognizes that removing unanimity silences dissent. That ties into the way that removing unanimity creates an ex post facto violation, because it makes it more likely, as it did in this case, that dissenting voices will not be heard. The jury, even in the capital penalty phase, is supposed to be expressing the conscience of the community. And so the jury, as I said, is instructed they never have to vote for death. They could be unanimous all day long on aggravators, on guilt. They still don't have to vote for death. And so by silencing any of that potential dissent over whether death is the appropriate punishment in a particular case, this removal is actually subjecting defendants to a higher likelihood, a substantially increased risk of a death sentence than they would have been exposed to.
How are you describing it as silenced? That's where I'm a little confused, because they voted, and in fact, in this case, we know their vote. 2 people said no. So how is that? I mean, the judge sees that when it goes to sentencing. How is that silencing the dissent?
Well, in the same way that the court talked about in Ramos, Your Honor, that the end result is, maybe they get to vote, but they can't prevent a death recommendation. And in Ramos, of course, the issue was guilt, whether one or two people can prevent a conviction. And it's a separate issue whether that distinction can be made, whether it's constitutionally proper to say it's okay to have unanimity for guilt and not for the death recommendation. But what I'm saying is that in the context of an ex post facto analysis, it substantially increases the likelihood that defendants sentenced during this window of unanimity would in fact get a death recommendation instead of a life recommendation. So I hope that answers your question. Yes, Your Honor. And I think there are some important distinctions with Daubert. One of the first things I would say is that when you look at the analysis in Daubert, it stops with that increasing the quantum of punishment language that I mentioned earlier. Daubert was a challenge to the statute that was enacted after Furman invalidated Florida's death penalty statute. And so Daubert was looking at an entire statutory scheme that was set in place specifically to address constitutional concerns. So there was a death penalty before that. Daubert kept the death penalty, and so in the context of that analysis, there was no increase in the quantum of punishment. Daubert was also clearly ameliorative, as the decision talks about, because it granted rights and protections that defendants did not have under the previous law. But Daubert didn't present the issue that you have here, which is that the law called for unanimity in sentencing, and then that protection was taken away for defendants in a certain window. So I don't think this court has to overrule Daubert, but I think that Daubert's sorry, I misspoke. You can't ignore what it says, but it doesn't control the outcome in the sense that Daubert simply didn't address the issue that's before the court here. Well, altering the methods by which the death penalty would be imposed, I think that language has to be read in light of Collins and some of the cases that come after that. Simply altering the method of imposing the death penalty doesn't end the inquiry if what you've done substantially increases the risk that a defendant will serve a higher sentence. And so Daubert can be read in conjunction with those cases. I think it was in Pew that the court said that we've never accepted the proposition that a law must increase the maximum sentence for which a defendant is eligible in order to violate the ex post facto clause. So the inquiry is really, is this defendant subject to higher punishment because of a change in the law? And for the people like Mr. Hunt in this window whose crimes were committed while Florida had unanimity, that is true. And Daubert simply didn't address that issue. Also, I do think it's significant that Daubert was enacted to address constitutional infirmities in the law. The unanimity requirement was abolished because the legislature didn't like that a particular defendant had not been sentenced to death. The motivation behind that change in the law was anger over a high-profile case, a terrible case, where. But the background of the law is significant, I think, because one of the reasons that the 8-4 was chosen was it was one more juror than voted not to impose death in that case.
Constitutional infirmities versus acting within their discretion. Isn't it a matter of whether or not it's within the legislature's discretion or not, and the motivation is not relevant?
The motivation isn't determinative, but since we're talking about ex post facto, when you go all the way back to the roots of the ex post facto doctrine in Calder, one of the reasons for the doctrine is to guard against vindictive or personal or specific changes in the law. So,
I mean, that's
not being happy that a particular defendant was going to be executed
but
is
counsel,
pretty personal.
There's more to the history here. Mm-hmm. I mean, the legislature adopted the requirement for a unanimous decision by the jury in response to a decision from this court. Am I correct?
Your Honor, this court made that decision in 2020, if I remember correctly, and the legislature didn't act until 2023.
No. Hmm? Well, I'm talking about when they originally adopted the requirement for unanimous.
Correct.
That was in response to a decision from this court.
Yes.
Okay. Well, subsequently, the decision was. That decision was overruled by this court. Mm-hmm. And so when you're looking at the sequence of events here, I mean, I think that puts it in context. Now, I understand the point you made at the outset in response to my question, focused on the delay in the legislature. Well, okay, the legislature does not always act with lightning speed, okay?
No, but as Hearst shows, the legislature can when it wants to.
Well, I mean, if under absolute necessity, they can. But I think all of that context has to be borne in mind when you're trying to evaluate what the legislature's done here. I'm not sure it makes any difference for your argument, really, on the legal issue, as Justice Sasso was pointing out. I'm not sure how that affects our legal analysis, but it is relevant to understanding what the legislature, the sequence of events in the legislative process.
I don't disagree with any of that context. I think to the extent it has legal significance, it certainly supports that the removal of unanimity is designed to inflict more punishment on defendants. That's what the purpose of doing that was.
The moral point, though, of the whole ex post facto doctrine to give respect to this kind of basic notion of fairness, that people at the time that they're deciding whether to act, that they know what's going to be illegal and what the range of punishment would be for what they're going to do, and this just doesn't really get to that.
Respectfully, Your Honor, I disagree, because there is a qualitative difference between a unanimous recommendation and a recommendation that can be made with 4 dissenting votes. Unanimity has a purpose in deliberations. The unanimity requirement is what ensures that verdict reflects the so-called conscience of the community. A conscience that is...
It's not a verdict. I mean, it's not a verdict at that point.
It's very verdict-like, Your Honor. But
no, but I mean, yes. It's essentially, I mean, I don't, you could see someone kind of before they act sort of deciding, what does the law say about the severity of what might happen? What do they say about the punishment? You don't really, it's hard to imagine somebody thinking that, well, if I cross hurdles A and B, I'm, less likely to get the punishment that I know I'm subjecting myself to potentially by doing this, because there may, 2 people could sort of veto the decision of the other.
But the death penalty is already reserved for a small number of the worst offenders.
And that gets to the whole eligibility thing. This isn't changing any of the eligibility criteria in terms of the world. No,
but it is making it much more likely that people who cross that eligibility threshold will be sentenced to death under the new statute. And so for people whose crimes were committed when unanimity was required, that is a change in the law that affects their punishment and creates an ex post facto violation. And I see I'm getting into my time, my rebuttal time. So if there aren't any other questions, I will save what's
Thank
left.
you.
Thank you.
Good morning, if it's still morning, and may it please the court, Janine Robinson on behalf of the state of Florida. Quickly, as to the first issue on inextricably intertwined evidence, Justice, you hit the nail on the head when you saw that out of all of the witnesses that testified at trial, only 3 mentioned the 2 items which the trial court found were probative and outweighed any unfair prejudice and were highly relevant to the state's theory of the case, but more importantly, to Mr. Hunt's motives in this whole act, which arguably is a fact-intensive, somewhat interesting first-degree murder case. But his motivation was twofold. It wasn't just the sexual battery arrest warrant that he became aware of on April 1st when he was in court. 2 days later, there was also an arrest warrant for human trafficking for the same victim. Pia was the victim in both of those arrest warrants. So he was well aware of what was going on when he decided to flee the jurisdiction. But as to some of the comments, with respect, I do say that counsel has overstated the level and scope of the testimony that was given. For example, the going, quote, back and forth between cities and having where the prostitution took place. That's a misstatement of the testimony. The back and forth was in Ms. West's testimony, talking about when the four of them left after the hurricane because they had no place to stay and were gone for 4 months. They came back to check on Mr. Hunt's business, not going back and forth for the purposes of prostitution. So that is a misstatement of the testimony. Also, in Ms. West's testimony, she denied that any prostitution took place while they were away. She denied it on the stand twice, actually, on direct examination.
What was the nature of the, wasn't there a curative instruction as well from the court?
Yeah, actually, it wasn't just a curative instruction. The trial judge was on top of this issue from the very beginning, from the hearing on the state's notice of the similar fact evidence, which in the hearing, the prosecutor said, we filed this just in an abundance of caution. We're not saying it's similar fact evidence, but there was a detailed hearing, and the judge was very cognizant that this is going to be limited. Extraneous details or salacious details are not going to be permitted. This will not become a feature of the trial, and the judge said this more than once, including during trial when there was a preemptive objection to some of Ms. West's testimony. And defense counsel only objected twice for contemporaneous objections. And it was sustained in part, and this was to...
do you know, just as an aside,
yes, sir.
Do you know, are there any other charges in the indictment other than murder in the first?
Absolutely.
Okay, so is there any argument from the state that this evidence could be inextricably intertwined or even directly relevant to any of those other charges, or did it just come in with respect to the first degree murder charge?
It is my recollection. It was really the main focus was Mr. Hunt's was motive and intent to kill P.O. and some evidence to take out the rest of the family because of the attempted first degree murder charges as well. So his motive went to the inextricably intertwined evidence went to a lot of things, not just motive. It was his premeditation. It was his intent. It was to put this whole semi-convoluted fact pattern into some meaningful scope for the jury to understand what was going on. So that's why there was a lot of this evidence in, but Mr. Hunt's counsel has not pointed out where they crossed the line. I mean, defense counsel objected when he felt appropriate, and the trial judge sustained in part and allowed the state a little bit of leeway, not much. And like I said, there was no details of exactly where the prostitution took place. There were no salacious, intimate details, which arguably would have gone beyond the bounds of relevancy. So we don't have anything here to show that it went beyond that, and there was no abuse of discretion in any of the court's conduct throughout trial. And if there are any other questions on that, I'll move on. Okay. To briefly address Ramos, as Justice Curiel brought up, Ramos dealt with the jury's guilty verdict. No more, no less. That is not to say Ramos is not applicable to the guilt and penalty phase in a capital trial. It absolutely is. However, it's very limited. The scope of Ramos's application to the penalty phase is the jury's finding, the factual finding of at least one aggravator, which must be unanimous and beyond a reasonable doubt. That's the extent of what Ramos applies. And I believe it's actually that simple. Any further questions?
Well, your friend sort of bank shots off of Ramos to talk about ex post facto.
Yes.
So maybe that's where you're going next.
And that's where I was going to go next. Ramos was the easiest one to go into. There's a lot of things to cover with counsel's arguments on ex post facto. First of all, in order to be an ex post facto violation, the statute or the amendment must change the definition of the crime or increase the punishment. There are two other elements under Calder versus Bull, but what we're focusing on here is the increased punishment. Mr. Hunt was exposed to a possible death sentence the day he was involved with the murders in April of 2019, and he's still subject to a death sentence when he was sentenced, when he went through his penalty phase in September of 2023. We talked a little bit about retroactivity. The statute amendment was enacted in April of 2023. Mr. Hunt's penalty phase didn't even begin until 5 months later in September. So we have no retroactivity issue. And not to Justice Kennedy in Love, that it's a common sense determination of where retroactivity begins. And I know we're getting a little bit into the savings clause, but it's very helpful to understand that the date that is applicable for retroactivity is past the date of enactment of the statute. So that's where we are in this case. We do not have a retroactivity problem. The second issue is the amendment is quintessentially procedural, and this court has said so. It did not change the definition of the crime. It did not increase the punishment. It merely changed and altered the mechanism by which a death penalty could be arrived at.
What is your response to the argument that mechanism makes it more likely that the penalty will be imposed in this specific case, and therefore...
Are we talking about the Pew analysis?
That was counsel's argument.
There is absolutely no evidence and no indication that lowering the recommendation would increase the likelihood of a death sentence. There isn't any. I'm not saying it doesn't increase the likelihood of a recommendation, because obviously, on its face, it would. But the litmus test is, does it increase substantially and significantly increase, if we're talking about Pew, significantly increase the likelihood of a death sentence? And we would say no. We don't know that because on a number of things. One, the United States Supreme Court has said that recommendations aren't even required under the Constitution, much less a unanimous one.
Imagine the legislature had enacted a new aggravator having to do with sex trafficking. Would that be more or less? Is that closer to the line? I mean, it is arguably going to make the penalty likelier imposed in this particular case. Or I presume the state's position would be that too is procedural.
Well, and it's interesting that you bring up the aggravators, because that's an interesting topic, because the U.S. Supreme Court hasn't spoken on the number of aggravators being whether the number of aggravators takes away any of the safeguards, where a high number of aggravators increases the lack of safeguard for and protections for the defendant. So in counsel's brief, she pointed to a Harvard Law Review article, which had a stat in there of, well, 90%. Okay, 90% of states that had 10 or more aggravators, states with 10 or more aggravators had a 90% increase of recommendations or death sentences. We don't have that. This court doesn't have that data. They were talking about Florida.
But I mean, an aggravator, if that were the only aggravator in a specific defendant's case, I mean, that would be that. I mean, the Supreme Court has said that aggravators are de facto elements, and so that's like essentially a new crime. I mean, so that's a completely different issue.
It's a totally different issue. We're not even talking about that. I don't mean to not answer your question. It's just
no. I think you have. It's a different issue.
Yes.
I'm hearing you say that the answer it sounds like is it's closer to an ex post facto violation than this would be.
Yes, and it would have to be evaluated on its merits, on its own. You know, if and when it becomes a ripe issue. Let's see. Okay. Daubert, in this, especially in Mr. Hunt's case, controls. I know there was some discussion of whether it does, and in Lobato, Justice Sassa, you're referring to the Lobato case out of the 6th DCA, which it was the only substantive DCA opinion talking about the 8-4 amendment, and the Lobato court held that yes, the amendment was procedural, did not violate ex post facto, applying Daubert. However, they also looked at Pew. They rejected Pew's significant risk test, but they applied it anyway. They did it in the alternative and still found there was not substantial risk. Because again, Pew was the Pew court had to its benefit empirical data that showed that federal sentencing guideline increases, and in Pew's case it was dramatic. The exposure was doubled. Mr. Pew was sentenced to double what he was originally exposed to when he committed the crime, thereby making it a substantive change that Mr. Pew was exposed to. So the Pew case and the federal sentencing guidelines were different in kind than what the Daubert case looked at, which was Florida sentencing statute. And it said that change in adding the MITs and the aggravators, again, was merely just the altering the mechanism of how a death sentence is arrived at. And the bottom line is, in this case, in any capital case, a capital defendant has 2 bites at the apple. There are 2 chances at life, first before the jury and then also before the judge, because judge is the final arbiter. So,
but I mean, it seems like the substantial risk thing, that's more of sort of a conceptual, I mean, it seems like that's more of a conceptual issue as to whether that should even
It is. And
because obviously, I mean, there's a hope for substantial, I'm assuming you wouldn't change the law if you weren't hoping that it would change things on the ground. I mean, it's obviously a reflection of the fact that these are very serious crimes, and, you know, they had a rule that tied the judge's hands, and you know, and they want to loosen it up.
But
for potentially completely valid reasons.
Right.
But I mean, you assume the legislature is hoping that when it changes things, that it will produce effects.
And they know, and the legislature knows what it's doing. But like it was also mentioned earlier, it's not for this court to be mired in legislative intent or policy decisions or motivations or moral arguments about it. This court is to look, does this amendment violate the ex post facto clause of the United States Florida Constitution? That's what's before you, not why did the legislature do it or what lobbying happened to get that legislation forward. Let's see. I do want to touch briefly. Council raised the savings clause issue. I know she didn't mention it, but as we stated in our brief, it was not preserved. But in any event, savings clause savings statute requires a prospective application of the amendment, which again happened in this case, 5 months after the enactment of the amendment. And honestly, I believe the state is concluded, unless this court has any other questions.
Thank you. We appreciate it.
Well, with that, we ask you to affirm the conviction and uphold the efficacy of this new amendment. Thank you.
Your Honors, regarding the Savings Clause, I will just point to the language in the Savings Clause that refers to a violation of the statute based on any act or omission occurring before the effective date of the act, which is what we have here. But going back to the ex post facto argument, we have data. We have all the data this court needs. We have a defendant who was sentenced to death, who received less than unanimous recommendation and therefore could be sentenced to death, who would not have been sentenced to death if this unanimity requirement was not imposed. That is the purpose of the act, and the court doesn't have to get mired in legislative history, but the court can look to what is the purpose of this act. The removal of unanimity was designed to be able to sentence more people to death, and that's exactly what it did in this case. So for the people who were sentenced in the window of time when unanimity was the law of Florida, this is a retroactive change in the law that increases their punishment and violates the ex post facto clause. There are no further questions. We ask that you reverse. Thank you.
Thank you very much. Okay, our last case this week is Jackson versus State of Florida, number 2023-1298.
May it please the court. My name is Megan Byrne on behalf of Michael Jackson. While Mr. Jackson's case raises multiple issues that merit this court's attention, I'd like to primarily focus on two ways in which the trial court's failure to follow the law deprived Mr. Jackson of a fair and reliable sentencing. The first is incorrectly instructing the jury as to their sentencing role, and the second is by ignoring the statute which precludes application of the 2023 sentencing law to Mr. Jackson's case. So for the first issue, this court should vacate Mr. Jackson's sentence because in instructing the jury, the court violated Caldwell in a set of facts that has never been before this court before. This isn't like the previous Hearst-induced Caldwell claims where the word recommendation applied to a statute that had no binding life possibility at the end of it. Caldwell is of course concerned with misleading the jury and seeking to minimize their role and their responsibility as a sentencing authority. Here, the trial court's claims went to the heart of Caldwell because it misled by essentially equating life and death votes as both something that could be altered by the court. Of course, the statute passed in 2023 says that if there are 5 votes or more for life, the court shall pronounce a life sentence, and so it is bound to do so. The court's instructions were also contrary to the jury instructions that came out just months after. Those jury instructions said that the jury needs to be told that that 5 or more votes for life are a binding life vote, that the court shall impose a life vote in those circumstances. And as I said, Caldwell is concerned not just with the misleading of the jury, but that when we mislead the jury, that we're seeking to diminish their sense of authority or responsibility. Here, the trial court said over and over again that...
Well, in the focus on diminishing their sense of responsibility for the imposition of a death sentence, there's no argument really about that here.
Well, it's about the diminishment of their sensing responsibility as to whether or not death is appropriate. So life or death. The emphasis is on the decision to the fact that they're making this very, very important decision as to whether or not someone should be sentenced to life or death, and their authority to do so, and their empowerment in doing so. And the court said over and again, and I'm quoting here from the record, page 1710, "I do not want the jury thinking they are solely responsible for the sentence. I don't want the jury to think they're responsible for it when the law is clear that I am." And of course, that was the previous the previous state of the law. The court used to be responsible for it, but under the 2023 amendment, a life vote means that the jury is responsible for that sentence. It means the judge.
Let me ask you this, counsel, on this. In the trial court, was it ever actually expressly argued that the failure to inform the jury that a recommendation of life would be binding was problematic, or that there was an objection to specifically on that basis?
Defense counsel objected multiple times on the court's use of the terms like recommendation without clarification.
Well, I understand that. I understand that there's talk about recommendation.
Yes.
But that doesn't seem to be, your argument really goes beyond that. Your argument, if I understand your argument on appeal, is that the error here was the failure to inform the jury that a recommendation of life would be binding. And I don't find that argument being expressly made in the trial court. Am I missing it?
Yes. Well, first, so our argument is.
Well, tell me,
yes.
if I'm missing it, tell me where it is in the trial court, where that particular argument was made in the trial court.
So on page 1711 of the transcript, defense counsel said that the jury shouldn't, or that the judge shouldn't be suggesting to the jury that the verdict is advisory and these kinds of terms when, if it's not a certain vote, it's for life, that it's going to be binding for life if 5 or more vote for life. So that is the place.
One problem with this argument is that, of course, the same thing is true with any numerical breakdown, including unanimity, right? Even in the case where unanimity is required, the judge's sentencing discretion is constrained by the jury's recommendation. The question remains, there is an element of constraint to judicial discretion in applying the death sentence. The statute didn't change that. The judge still remains the sentencing entity, right? What has changed is the nature, the triggering event for constraint. Instead of being 12-0, it is 8-4. Do you disagree that your argument would apply equally to the prior regime, or am I wrong?
Well, under the prior regime, there was, I believe it was 10 at that time, 10 votes that were needed for a death sentence, and less votes that would require a life sentence. But here, the issue is not just recommendation, but recommendation in conjunction with nothing to say that actually one way is a recommendation. If it is a death vote, that is a recommendation. The court can alter that, can go life or death. But if it is a life vote, that is a binding decision. The judge will have no discretion to...
Just as binding if it were 10 or 12 or 8. I guess that's my point. My point is the argument seems to me to prove too much because it would have applied equally to the prior regime. Can you respond to that?
I think it's about the misleading of the jury. So here, when you tell the jury over and again, if it's 8-4, that's a recommendation for death. If it's less than that, that's a recommendation for life. So the jury, whatever preconceived notions they might have about the effect of their verdict, is being altered by the fact that the jury is being told repeatedly, this will lead to a recommendation to the court, this will lead to a recommendation to the court, whereas, so it's being affirmatively told this is going to be a recommendation, but not being told, really recommendation isn't the right term we're using there, because if it's life, it's not a recommendation. So that's the problem. It's that affirmatively misleading the jury by using the term recommendation without any kind of clarification that it's really only a recommendation in one set of circumstances.
So under the old, your argument is that under the old law, if the judge had done the same thing that said, you know, if you come back with, you know, a non-unanimous verdict, that's a recommendation for life. That's the same type of mistake you're claiming here. It would have been the same. It's the focus on that the recommendation for life or death is still up to the judge. That is what the jury was led to believe, even though that's not true.
And here, you know, there are indications that, again, this was the goal of the judge. The judge said over and again, this is what I want the jury to think. I don't want the jury to feel responsible. And so that's why the judge instructed as he did. And there's also indications in the record that this had an effect, right? So the jury came back with the closest vote that there could be in a death sentence, 8-4, after just 2 hours of deliberation, after a 15-witness, 5-day trial, 2 days to come back 8-4. So there are indications in the record, as far as one can find them, that this did have an effect on the jury taking its role and responsibility seriously, and knowing that if it came back, for instance, 7-5, that would mean a binding life vote. It was never told that, and it was affirmatively misled into thinking that there's no such thing as a binding recommendation.
Can we unpack that interesting adverb, affirmatively and misled?
Yes.
I mean, let's agree, perhaps, you certainly don't think the court was maliciously trying to misrepresent the state of the law to the jury. Okay. Do you think the court was purposefully, if not maliciously, trying to misrepresent the state of the law?
From the transcript, it seems as though perhaps the judge said at one point that the law is clear if you go back 2 years, that it rests on the judge, and that's not accurate. That's not wholly accurate. That if it's a binding life verdict, it doesn't rest on the judge. So I'm not at all saying there's malicious intent behind this, but it was incorrect. The judge was incorrect in what he said, both outside of the jury and before the jury and to the jury.
But I think there's quite a chasm between what you just said, which is, let's say your argument is that it was incorrect, and affirmatively misleading, which you keep saying.
You just mean affirmatively misleading as opposed to misleading by omission.
Yes. I mean that
he told them something that was wrong.
Yes, I do not mean that he had the intent to mislead, and he was trying to say, I want the jury to think one thing, even though that's not true. I don't think that. What I'm trying to say is that it wasn't just a silence and what the jury figured out. It was an affirmative misleading in that the jury was told something that would make them believe, understandably, that either way it's going to be an advisory sentence, essentially, just like the old law was. In the old law that was passed in '95 that no longer is operable. And if I could, I'd also like to quickly turn to another issue that has not yet been considered by this court, which is that Florida Statute 775022, subsection 3A, bars application of the 2023 amendment to Mr. Jackson's case, such that this court should vacate Mr. Jackson's sentence and remand for resentencing under the prior law, the 2017 law, the unanimity law. And this is a textual argument based on certainly the text of 775022, which makes clear that the 2023 amendment should apply prospectively and should not affect sentencing that were to take place under the 2017 law.
Okay, now you're relying on 3A, right?
Yes.
Okay, so the prior operation of the statute.
Yes, Your Honor.
Well, the statute didn't operate previously. There is no prior operation of the statute. What this savings clause is about, it's about not going back and undoing things that have been done. Here we're talking about something that hasn't been done.
He hadn't yet received his sentencing, but what he had received was an order back in 2017 to receive a new resentencing pursuant to Hearst and
But the sentencing
unanimity.
hadn't been done.
The sentencing hadn't been done. The order hadn't been done.
There was no prior operation of the statute. I'm puzzled by how you can find a prior operation of the statute in the context that is here.
Yeah. So when in 2017 Mr. Jackson was given a resentencing, argument is that at that point it was under the prior operation of the statute that was in place when the resentencing was ordered, and in fact was the point of the resentencing, the point of the final order. But the rule is on these procedural things that the law in effect at the time the procedure is carried out is the law that applies. Well, 775.
We've got cases on that.
Well, 775 and 775, the legislature made it a point to explicitly say two things. One, that this means a statute that is substantive or procedural under 775022 subsection 2, and also said explicitly that the law could have explicitly state otherwise, that it should also operate retroactively. Many laws do state explicitly that they operate retroactively, but here the 2023 law didn't. So I think the fact that the legislature put in the statute, whether procedural or substantive, goes to this issue that this is meant to apply to all criminal statutes of all kinds. And if I could, I will just very briefly touch on two interrelated issues that are regarding information that the jury was deprived of, that are kind of working in conjunction with this Caldwell issue where the jury doesn't know about its sentencing authority. The jury was also deprived of knowledge that the co-defendant, whose testimony was read into the record, later recanted that testimony. So the only version of events was that one co-defendant's perpetuated testimony. He didn't testify live. And that was recanted, but the jury was never made aware of that fact, even though defense counsel asked for it to be made aware of that fact. And second, the jury was also not told that another co-defendant had a life sentence, had been given a life sentence, despite the fact that he had, a heightened responsibility in this crime. And that was another thing that counsel asked for, but was denied. So we have a jury who is being misinformed as to their authority, who's not learning these two key facts. And so this is all working in conjunction in a case where, as far as prejudice goes, if prejudice is going to be found, this is the case. It's a close 8-4 vote. It was an 8-4 vote back in 2007 when Mr. Jackson was originally sentenced. At that time, he didn't present any mitigation. Here, it was a close vote after a couple hours, but there was a lot of mitigation that was presented, including Mr. Jackson's maternal abandonment by his biological mother, who at one point tried to sell him, the effect that her struggle with drugs and alcohol had on his neurology, the fact that he, had admitted responsibility and in 2011 even went back to court to openly in court express his remorse. Certainly that was way before he knew that there would ever be a resentencing for him. And he did gain the forgiveness of several of the victims' family members and had a lot of religious and personal development spoken to at the trial. So I say all this to say that if there's any case where prejudice is going to be found, this is the case, and that all these errors work in conjunction support that this court should vacate Mr. Jackson's sentence and remand pursuant to the law of unanimity as according to our 775022 argument. And I'll save my time for rebuttal.
Thank you.
May it please the court, Michael Mervine on behalf of the state of Florida. With the court's indulgence, Mr. D'Souza will be handling the 8-4 issue and I'll be handling the remainder which were raised. Here, there was no Caldwell error. Caldwell and its progeny hold that a jury must not be affirmatively misled as to its role to believe that the appropriateness of a death sentence lies elsewhere. Here, the court did omit the language about the binding effect of a life recommendation, However, the law remains in Florida that a recommendation of death is still a recommendation. The court can impose that or choose not to. Also, the comment should be read in context. The jury was advised that they needed to use their best judgment. They needed to realize that a human life was at stake, and also that they understand the gravity of the proceedings. This court holds that without evidence to the contrary, a jury is presumed to follow its instruction. There's no evidence here that the jury failed to do that. In addition,
but I'm sorry. So you're asking us to kind of consistent with what Justice Kennedy asked early in the argument, to read Caldwell as not for standing for this proposition that the jury, that it's a constitutional issue about misleading or misinforming might be the better word, the jury about sort of the specific consequences of the different recommendations, that the principle is limited to, do you know the effect of, if your role in actually imposing a death sentence? I mean, is that, because I'm not sure how. It seems like they're so closely intertwined that my role, if my my life quote unquote recommendation is binding, then it just seems like.
Well, I think that when the facts are viewed through the lens of Caldwell, then that is the conclusion. Caldwell involved a case where there was jury sentencing, so there was no judicial discretion. It involved prosecutor statements which were in response to defense comments that the jury was in effect a death squad, or they were murdering the defendant, and then the state got up and said, no, that's not true. Your decision is going to be reviewed by a higher court, even though that was somewhat a misstatement of Mississippi law and that the sentence was presumed correct. And the focus of the U.S. Supreme Court's opinion that this was an Eighth Amendment violation was false information of this type might produce bias in favor of death sentences. So the focus there, and the court submits in this case, is that the Caldwell analysis should focus upon a death recommendation and whether the jury was affirmatively misled regarding that. Also, the defense points to the lack of deliberate, or the short amount of time the deliberations took place, as well as the breakdown of the vote, stating that that's evidence that this jury was misled. However, their current argument is in contrast to what defense counsel argued in closing. On page 190 or 1790 of the transcript, counsel stated, and if I could read, "We also talked about in jury selection how each of you agreed not to go against someone's opinion, to let them make their individual decision. You certainly can discuss, and there's nothing wrong with discussing, and it's proper to discuss your opinions and talk about things and give your opinions about the evidence and the witnesses and so forth. But at the end of the day, it's your decision and your decision alone." So that seems to be in contrast to what appellant is arguing now, that if these 4 jurors had known that a 5th juror would have mandated a life sentence, if they could have persuaded that person to vote with them, that's the error in this case.
Do you have the counsel on the other side cited 1711 of the transcript for where the specific argument was raised? Do you have a specific comment in response on that?
Well, the court was responding to the defense asking for a jury verdict. So they wanted the term verdict to be used, and that, of course, isn't what is provided in the statute, as it still remains a recommendation as to a death recommendation, a death sentence.
Is the state's position that the argument they're making here regarding the violation, Caldwell violation, was made below? I didn't see that you You didn't say that it wasn't, so is that the state's position?
They certainly cited Caldwell, and they argued Caldwell, and I think many of the quotations the appellant is citing, the court was referring, although it's not explicitly said, to a death recommendation. The court didn't want the jury to believe that that was binding, and this was in fact a death verdict.
Well, wasn't there some argument by the defense that the change in the statute had, in effect, and I think the terminology was baked Caldwell error into the statute? So that there's some Caldwell a flaw that's created by the statute. Wasn't that argued?
That I don't recall, Your Honor. That I don't recall. And in addition, the context of this case demonstrates that any error was harmless beyond a reasonable doubt.
Sorry, I don't mean to interrupt you. So what's the bottom line, though? Do you believe that they preserve this argument on the sort of the specific, not just a Caldwell issue, but this specific claim that telling that it was, error, that the court was put on notice that the court was committing error by not drawing this distinction for the jury between, the recommendation of death and the quote unquote recommendation of life?
I would concede that they cited Caldwell, and they argued that the jury instructions as proposed by the court and given to the court violated Caldwell, but not necessarily that the failure to instruct the jury that 5 votes meant a mandatory or would be a life sentence. No.
They did not. So when they were presented with the proposed jury instructions, they did not actually say these are erroneous because they failed to inform the jury that a recommendation of life would be binding.
I don't believe so, Your Honor. I don't believe so. Also, in light of this gruesome crime, any error the state would argue was harmless beyond a reasonable doubt. It's pure speculation that any of these jurors would have been open to a life sentence hearing the facts that they did, or that those 4 jurors felt strongly about a life sentence to the extent that they would have deliberated more aggressively.
Do you think the harmless error analysis should be affected at all by the 8-4 vote versus what would have previously been unanimous, or we wouldn't be here?
I'm sorry, Your Honor?
So, when we look at the harmless error, we're saying but for this error, would the jurors have considered a different vote? Do you think the fact that this is an 8-4 now that we're looking at should factor into that? Does it make it more likely to be harmful?
I don't believe so, Your Honor. As I quoted defense counsel closing argument, he urged them to basically not aggressively litigate, and it's pure speculation that any of those jurors, either on life or for death, were uncertain or didn't follow the court's instructions to use its best judgment when they gave their recommendation. And quickly, counsel addressed the recantation of co-defendant Nixon. This confrontation clause argument is unpreserved. The state law abuse of discretion argument might be a close call, but nevertheless, this was definitely harmless beyond a reasonable doubt. This perpetuated testimony was read to the jury. Within that perpetuated testimony, Nixon was highly impeached. The jury learned that he had previously lied to the police, that he talked on the phone with someone about coming up with a story to lessen his culpability. He also received a deal. The jury learned that he wasn't sentenced to life, but instead to, I believe, 55 years to life. They also learned that he was under the influence of methadone when he led police to the grave. In addition, the jury heard appellant's own statements, and those were recorded statements. And within those statements, he admitted that this murder plan originated with him. He was the leader of it. It was his idea to bury the victims alive. It was his idea to target them because they were infirm. And he admitted that he used the victim's property after robbing them in their house and placing them in their trunk, driving them to the makeshift grave. Finally, the admission of the co-defendant's life sentence. In Eddings versus Oklahoma, the U.S. Supreme Court set forth constitutional mitigation, which is highly individualized. It focuses on the defendant's character, his record, and the nature of the offense. The sentence of co-defendant Wade isn't probative of any of those. Also, the presentation of such evidence is problematic because for it to have any meaning, the jury would have to learn of the aggravators, the mitigators, and Mr. Wade's involvement in the crime. So it would basically be a trial within a trial. And then...
I'm sorry to interrupt you. Could you just take a couple of seconds to wrap up?
Oh, I'm sorry. Yeah, this is my final one. This court's decision in Cruz v. State certainly shed some light on the issue. That case addressed relative culpability review and concluded that just because the defendant is involved to the same crime is irrelevant to his co-defendant's sentence because the aggravators, mitigators, and involvement are different. Thank you very much.
Thank you.
Mr. Chief Justice, and may it please the court, I won't tax the court's patience. I'll just say a few words about the allegation here on retroactivity. So all that the Savings Clause statute requires, whether a new criminal law is substantive or procedural, is that it be applied prospectively, and I agree with everything that Justice Kennedy said about that issue. This is basically controlled by Love and by their, I think, tacit concession that this is a procedural law. So 775.022.3a would prevent a trial judge from reopening a closed penalty phase to retroactively apply this procedure, but a valid prospective application is one that is forward-looking to all penalty phases that hadn't yet occurred. Are there any questions that I can answer for the court about any of the SB 450 issues? Thank you for your time.
Okay, thank you.
Thank you. Just briefly, I do have 1711 that I was citing to you up, and I would just direct the court to the place where defense counsel says, I'm concerned with the idea that it's suggested to the jury that their verdict is advisory, when if they return a verdict of life, it is not advisory, it is life, the court shall impose it.
Could I ask you, when did that occur? Was that after the proposed jury instructions were presented or before?
I believe it was, Your Honor. It was certainly before the charge was given, but I...
Well, but were they looking at the proposed jury instructions at that point? Because I understand that if you look at that all in context, I think the judge says, well, yeah, but I think the question here is when they actually, and maybe I'm missing something, but I think the question is when the instructions were presented, did they say, no, this is incorrect? This needs to be, you need to have this specific statement that a jury recommendation of life will be binding?
My understanding is that the instructions had been presented before this argument was made.
Okay.
Yeah, so, and I just wanted to underline that the burden is on the state here to show that they're under Caldwell. It's that there was no effect on the sentencing decision. And this is also an instructional error in that it contrasts with the statute itself, which says the word recommendation, but also says that if it's 5 or more, the court shall impose a life sentence. And interestingly, the jury instructions that came out also say the jury should be told that, but actually don't use the word recommendation as to a life sentence, likely to avoid this kind of, I think, confusion. And under the instructional error, the state would have to show that this is a harmless error, and also it would be speculative, I think, to show that as well. And here, so the jury was simply misinformed. It was deprived of the power that the legislature has given juries ever since the 2016 edition of the statute to decide life, rather than just recommend something to the court that the court can then change. And as to the co-defendant sentence situation, this court has, in Florida, has looked for a long time at co-defendant sentences, and I think it's particularly significant here, where this court no longer does comparative proportionality review, that the jury be given this information so that it can make a determination. And of course, it's up to the jury to decide how much weight to give the fact that a co-defendant got life here, and the other co-defendant got 45 years. So the jury was told that, but was not told that this other co-defendant, whose role was alleged to be more serious, that he got a life sentence as well.
But do we have to expand our concept of mitigation to really consider that mitigating? Because it doesn't have anything to do with the defendant's background, character, etc. It doesn't really have anything to do with the offense. Where would we, and I understand that there's the statements in the cases and stuff, but if we were going to be kind of focused and precise on this, how would we say that it fits within the concept of mitigation?
Well, I would say something that the jury was told in this case, which the jury was told that mitigation is anything that supports life. A life determination is mitigation. That's what they were told to consider. So certainly this would have fallen in the ambit of that had they been told about the co-defendant sentence. And while they were, yes, given the general instructions that the state points to in terms of take this seriously, not only is that true in most death penalty cases, but it was even true in Caldwell. And the Supreme Court in Caldwell said, yes, they were given these general, instructions to take this seriously, but that wasn't enough to get to the specific error, because those instructions didn't go to the specific error of all of the messages the jury received in terms of not taking responsibility.
Again, let me ask you about whether you, at the trial level, there was actually an argument presented to the trial court that this life sentence was mitigation. That the co-defendant's life sentence was mitigation. Was that argument actually made to the trial court?
I believe that was the tenor of the argument. I don't know that the defense counsel used this is mitigation.
Wasn't that
sentence,
focus more on the court that there had been some prior order?
Yes.
But there wasn't any discussion of mitigation. So the trial court, I mean, unless I've misapprehended this, the trial court would have had no way to know that you wanted to submit this as mitigation because you aren't saying it's mitigating.
Well, the prior litigation was just about whether or not there could be the introduction of other sentences, not the co-defendant, but other sentences, other cases that weren't similar to this one, or that weren't very similar. Whereas this discussion happened later and was a distinct argument just as to the co-defendant's sentence, and presumably the defense counsel wanted it to be presented to the jury because it is mitigation, and it was.
But did he say that? Did he say it's mitigating and I'm entitled to put it in because it's mitigating?
I really couldn't say that he used the exact word mitigating or not. He might have, but that certainly was the tenor of the argument.
And the argument is that it's mitigation that they're entitled to get in. It seems to me it's incumbent upon the lawyer to tell the trial court that it's mitigating evidence that they're entitled to get in.
I don't think that there's any other reason for which the defense counsel would have asked for that to be entered in if it weren't to serve as a piece of mitigation.
But again, it's about apprising the trial court of the specific basis, not like, well, what you're saying is, he must have. We expect the trial court to know that it was that they wanted in because it was mitigating when they weren't informed. When the trial court wasn't informed that it was that they contended it was mitigating. But I'm understanding what you're saying, right?
Yeah. Yes. You
okay.
understand what I'm saying.
All right.
And yes. So we would. Based on that and on the prejudice of that, certainly, and related to the recantation as well, that would warrant reversal. But in terms of the Caldwell error, I did want to uplift, as I said, it is an instructional error. So even if even if this court doesn't feel that it undermined the jury's sense of responsibility, which we argue it very much does, and there's record evidence of that. But even if this court didn't hold that, this did conflict with the law itself, which does use the word recommendation, but then says that 5 or more votes for life is binding. And so this court could also reverse on those grounds as well. And if there aren't any other questions, I will rest.
Okay, thank you very much. We're adjourned.